All right. Good morning, everybody. Thank you so much for being with us for our Handbook Essentials course. This idea derived from our HR committee, which meets monthly at the end of every month. A group of HR professionals or folks that wear that hat within their brewery space meet to talk about different issues that are impacting our brewery, that are impacting new law changes for employees and employers. And the goal is to just share best practices with one another, not reinvent the wheel at every single brewery. We're all working really hard in small businesses, so we want to try to make accessing HR tools as easy and as painless as possible, which is why we've brought in Sharon from MP Wired for HR. MP has been an associate member and supporter of the Guild since I've been onboarded here in 2016. So they do our payroll. They're fabulous. They send us all the posters and stuff for our staff room of one. So I make sure I'm in compliance with myself, but it's a good tool to have. I know several of our other member breweries work with them as well, and they're very highly trusted. So I've done enough talking. I'm going to turn things over to you, Sharon. And also, if you have questions, feel free to type them into the chat at any time, but we will get to all of them at the end. We just feel like we want to keep the flow of the presentation moving along, but then we will absolutely save time at the end for questions. So without further ado, take it away.
Thank you, Katie. I appreciate the introduction. Again, my name is Sharon. I am the senior HR partner at MP. So today I'm here to go over some handbook essentials and to cover some policies on best practices on how to create a handbook, what ideally a handbook should include, and maybe some more specific to the restaurant brewery industry, because as Katie and I spoke about a month ago, that was one of the things that she brought up, is that there could be some policies or concerns that you as brewery owners might have questions about regarding doing certain practices that may or may not be in compliance under federal, state, or any even OSHA safety laws, right? So let's get started. So here's a little spiel about what MP HR is about. As Katie mentioned, we are a payroll company that also offers human resources support to our clients who would like to have some help with setting up things such as handbooks, job descriptions, advise on HR laws, staying in compliance. So this is part of our extension of MP that we offer these types of services. So I myself work with a number of clients throughout the Massachusetts area, as well as other clients outside of the outside of Boston, outside of Massachusetts, and we are also doing a lot of these types of seminars for our clients on an on-demand basis. And if you visit our website, there should be a link to other webinars that we've hosted in the past that have been recorded and posted for basically anyone that has access to that. So if you are interested in taking a look at it, please do so, because there are a lot of upcoming topics that are very fresh, hot off the press, such as AI, accommodations requests, because a lot of business owners are now facing a lot of questions about employees needing accommodations for physical or mental health being. So those are things that we cover with our clients. And just a little spiel about myself. I've been in the HR business for about 2 decades. I have a background, a degree in psychology, concentrating in industrial organizational psychology. And I've worked with various companies. I've worked with nonprofits. I've worked for for-profits. I've worked for a larger corporation before coming over to MP about a year ago. And I've always enjoyed working with employers such as yourselves to help them understand what they need to do to promote a compliant workplace, but on top of that, to make sure employees are happy and they understand what their expectations are, so that employers and employees can work in a harmonious environment. As with all our presentations, I do have to go through a quick legal disclaimer that our presentation today is purely for educational and informational purposes. So I'm not a legal advisor. I don't have a law background, nor do I have a law degree. So this is not any type of legal advice that I'm offering you today. I am simply providing you information on best practices with regards to the handbook creation, and that all the information that I've included today is up to date as of today. If there's any additional updates, that's something that you can talk to Katie about, who can relay some of those questions for me. But we're mostly concentrating in Massachusetts law today because I know most of your businesses are in Massachusetts, but if there's anything beyond that, we can feel free to dive right into that later on at the question and answer piece. So just to go over what we're going to talk about today, this is the list of topics that we'll be presenting. Why do I need to have an employee handbook? That's the $1 million question. Most small businesses I've worked with many years say, we're like family, or we have been in the business for a long time and we haven't run into any situations in which, a handbook could have helped us. So we're going to talk about why it's important to have an employee handbook, and also what to include in your employee handbook, because it's not a one size fits all. Different industries, different employer sizes, different states that the employees in could affect how your handbook will be produced. Some policies to update and keep in mind for 2024. There's been a lot of changes happening over the last year, and some of them are still coming out. So we'll talk about some of these things that you do need to be mindful for when creating your handbook this year. And then at the very last of our presentation, we'll talk about some top 10 handbook mistakes to avoid. So some things that you think you need that you don't need, or some things that you don't need, you don't realize you do need to be in the handbook, and just on how to go about creating policies. So those are things that we'll be covering at the end of the session. So the employee handbook provides employees a detailed overview of policies that are specific to your company, along with other key guidelines and benefits. In a nutshell, it sets clear expectations for your employees while also stating your legal obligations and defining your employees' rights. So the handbook can help protect your business against employee lawsuits with claims such as wrongful termination, harassment, and discrimination. The handbook is also a crucial introduction to your business for new hires because it sets the tone as to what the expectations are in terms of what the employer expects from the employee, and vice versa, what the employee should expect from the employer, providing insights to your company's missions, values, and cultures. So in terms of communicating expectations, the employee handbook can help with compliance with state and federal laws and be a go-to source for employees and showcase company benefits. Most importantly, it's a tool for managers to deal with workplace issues and ensure consistency and fairness in applying workplace rules. Because the one thing that we HR professionals always say is always go with a consistent and fairness across the board, right? Again, it's not a one size fit all type of situation for many companies. But if you're going to be setting up certain policies and procedures and you have that written in a handbook, it's important that as an employer, you do try to follow that and stick with that so that you will minimize any chance of being called a unfair employer, or that you're being discriminatory in any sense. If you ever have to defend the company in an employment situation, having a handbook that you have given, reviewed, and the employee has acknowledged receipt can be a key defense should the employee claim you did not convey certain standards of conduct, and then the employee was terminated for violating a policy. A company looks more buttoned up and professional in a court of law, and more professional to the employee. And we all know it is hard to attract and retain employees currently. As I mentioned before, not all handbooks are created equal. It really all depends on certain criteria, right? So the first thing that you need to consider is the size and location of your company, the number of employees, what locations you're in, and what states that you operate out of. In most handbooks, I shouldn't say most, I should say all handbooks, it should include laws that are on a federal level that covers all United States employees, plus the state-specific policies. Now, you may wonder if there's federal policy that's similar to what a state policy states, why do we need to have both sometimes? And the reason is because federal level policies sometimes are not as beneficial as the state policies are to the employee. So perfect example of that would be minimum wage, right? The federal minimum wage is really low. It's has not gone up a lot over the last couple of years, remaining at about $7 and I think $7.50 per hour on a federal level, right? But in other states are more generous, such as Massachusetts. We're right now at $15 an hour. So by law, employers do need to offer what's most beneficial for the employee. So in this case, if an employee lives and works or actually works in Massachusetts and is a non-exempt position, then they should be getting at least the state minimum wage of $15 an hour. Okay, so that's why it's important that when you have handbooks, you do need to make sure you have the federal policies, plus include all the state specific, and sometimes there are local laws. In other states such as California, which is an island of itself, right? They have local laws that only are applicable to those specific jurisdictions. San Diego has their own pregnancy, maternity leave. I think LA also has their own sick time. It's very convoluted. So it's important that if you decide at some point that you're going to be expanding into those different areas, you have a good HR consultant to work with so that person can help you determine what policies you need in those handbooks. Now, the other thing that you need to consider is the industry. So what type of industry you're in. So for example, I work with various industries. A lot of them happen to be education based. So your daycares, your private schools. So many of these schools do require specific details by the state that they have to have in there. So in Massachusetts, for daycares, they do require, for example, job descriptions included in the handbook. Even though by standard, job descriptions do not belong in a handbook, but because the state agencies require it, we will work with our clients to make sure that those are included in there. And it's up to our clients who are familiar with what their industry requirements are to let us know what we need to do to help our clients' handbook be cohesive in that sense. There's also government contractors, right? So if you have a government contract that requires certain details in there, then those are things that we need to be aware of as well as HR professionals to help you. And for unions, so most unions have their own agreement in which handbooks usually do not cover anything on a union contract. I'm sure most of you don't have a union, so this is something you don't need to be worried about. But just keep that in mind if in the future somehow you end up being a unionized environment, that your employee handbooks would not be applicable at that point. The last piece that you need to be considerate of is the workforce. So you need to think about diversity. It's basically key to all organizations. DEI is so hot right now. There's so many different topics, different seminars, different policies that go into play. You have to think about your employees in terms of their categories, whether they're full-time, part-time. Will you offer benefits to your seasonal or intern employees? And then there's also telecommuters. So in your industry, I'm not too concerned about telecommuters because most restaurants and breweries do require employees to be on site. But there could be certain positions that would allow these some employees to work off-site maybe once in a while. So you may want to put together some policies that talk to what the telecommuters' expectations are. And then finally, there's literacy, language, and disability. So depending on your workforce, you may have employees that don't speak English fluently. English could be their second language, or they may have a certain disability in which that they're unable to read a standard handbook. For someone, for example, who may have difficulty seeing, they have a vision impairment. So how would you be able to offer the policies for them to review? All right, so those are things that you need to be considering because we want to make sure that the policies are communicated across the board consistently, and that all employees have access regardless of what type of language they have, if there's any language barrier or any disability that could prevent them from understanding the materials. Some handbooks do's and don'ts. So here are a few tips on regarding what to do and what not to do for your handbook. It's important to put your policies in writing, but sometimes too much detail is not needed. So for example, when it comes to policies regarding your benefits, suggest putting a high-level summary, letting employees know which benefits you offer, and then refer them to look through the summary plan benefit. Honestly, with these types of group insurance plans, they change so much year after year because employers have to go through open enrollment. They may be making some modifications to plan in order to accommodate certain changes in the workplace. So it's best to keep that language as minimal as possible and then just have employees review the summary plan documents available to them for signing if they're signing up for these certain benefits. Make sure that you are applying policies consistently across the board. That's important. So if you're letting an employee use sick time as vacation time and not others, that would be a problem. If you don't follow what is in the handbook, your practice becomes your policy, meaning you're basically setting a new precedent. And then it is hard to enforce any type of policies moving forward with other employees. An employee or their lawyer could argue how did the employee know that they should or shouldn't do something in a policy, or if the company doesn't follow other policies in the handbook. You also do want to make sure that you are communicating your handbook policies to all employees. If you're a client of MP, you can make the handbook available to employees on iSolve and have it uploaded, in which you can also request employees acknowledge the receipt within a certain deadline. And that's a great way to communicate this information electronically and also track it online. When it comes to new laws coming out with our clients at MP, we're the first ones that would normally advise our clients when something's coming down the pipeline and that could affect them. So the latest one was on a federal level, the Form I-9s, in which employers must complete within 3 days of an employee's hire to ensure that they are legally able to work in the United States. This form only gets updated every 3 years, but it does not get released with the new updates on time. They're always about 4 to 7 months behind schedule, and clients rely on us as their HR partners to let them know when the new forms are out and let them know what the new changes are. And within the last update from the summer, there have been some significant changes to the form itself. So those are things that we would communicate to our clients. And that's something that we would alert our clients to be aware of and send them the new forms. And the last thing you want to make sure is making the handbook easy to read and understand. The handbook's not the most fun thing to read, I admit. It's a lot of detail, a lot of law information that you probably don't want to know as an employer, but you do have to know, and employees do need to know. So you try to make them as short and concise as possible within reason, right? So most of the handbooks written out there are based on local, state, and federal laws. So there's really not so much you can do to condense that information, but you do your best, right? And for some policies that are more company specific, you do want to be detailed, but you don't want to overwhelm the employees, all right? So the key is to make sure that it's a 10,000 feet overview, but also be able to include certain information that's pertinent and for employees to understand. So you do want to make sure that it's only policies and procedures that are in there. But anything that's operational wise, so you have a policy that talks about, for instance, how to use a machine in the workplace. Step 1, turn on the power on machine. Step 2, press this button. Step 3, release this lever. Those are types of procedural policies that should not be in the handbook because those are considered procedural. They're telling you how to use a machine. It's not part of what the company rules are. So in that sense, you do need to make sure that you are choosing the right language to include in the handbook so that it doesn't get too convoluted. Okay. So some must-have at-will language that you want to include are understanding and conveying to the audience that's reading the handbook is that the handbook is not a contract for employment. Sometimes employees misconstrue the fact that the handbook is only there as a tool, as a guidebook. It doesn't guarantee any type of employment um, uh, duration, right? So most states, including Massachusetts, is an at-will employment. And what that means is that there is no employee contract, and the employee or the employer is free to end the employment relationship at any time for any reason. Now, that's a very dangerous definition, I admit, right? What that really means is that the employee and employer is not on any employment contract. That's it, right? That's why they call it employment at will. It really just differentiates the difference between an employee that does not have a contract for employment versus an employee that does, okay? When it says in the language that employment relationship can end at any time or any reason, many employers come to me and say, yeah, I can just let an employee go tomorrow because he's just not a right fit, or we're getting a lot of complaints and we just want to end things very quickly and painlessly. It doesn't mean that you can just let them go anytime you want. As an employer, you should still have a justifiable reason to let someone go if it's because of performance or if it's because of behavioral issues. We always want to make sure employers have the right reasons to terminate someone and that you have proper documentation. At MP, we go through a whole training on discipline and termination process, including up to termination. So those are things that we cover with our employers. And plus, whenever a client calls me to say they want to apply disciplinary action or maybe possibly terminate someone, those are steps that we often have to take a step back and review the timeline and what the infractions are. So you do want to make sure that employees understand that there's no contract for employment, even though the at-will language is in there, okay? In terms of updates of the handbook, you as the employer retain the right to revise the employee handbook and the employment relationship at any time. You want to make sure you avoid using terms that imply job security or job guarantees, such as successfully passing your introductory period, rewarding a career with a company. You also want to avoid using the term permanent employment. In the categories of employment, they may ask about regular full-time, regular part-time, temporary, or seasonal employees. Those languages are chosen very specifically and very carefully not to imply any type of guaranteed employment, okay? If you also hire temporary employees and want to differentiate between the two, again, you also need to make sure that you are spelling out what those languages mean, all right? Regular full-time will be someone that is expected to work X amount of hours per week and will be able to receive benefits. And someone that's temporary seasonal will be hired for a short period of time, anywhere from X number of weeks to X number of months, for the purpose of filling in positions that are required during a busy season, for example. All right, so those are languages that you do need to make sure are in your handbook spelled out carefully. It's also a good idea to explicitly state that the handbook is not a contract again, and that you retain the right to revise the employment relationship. The handbook is a policy guide, it is not a contract again, and that you will communicate any changes that arises. So in the handbook, you should have a statement in there. This is that policies are subject to change, and only changes released by the president or the owner of the company are valid. Okay, so you do need to make sure that you have something like that in there to cover yourself, because policies and laws do change. So you do want to give yourself some leeway in terms of making that flexibility happen for you. All right, so to start off with your handbook, you want to kind of paint a picture of what the company is about. So it's a best practice to include a employee relations policy, sometimes called an open door policy, to talk about how employees are able to feel free to approach a company representative, whether it's their direct manager or someone above them, to speak about their concerns or any issues, all right? And that also should speak about their company culture and mission and goals, right? So employees do need to understand what they're stepping into. Ideally, during the interview, that should have been all conveyed to them when they were trying to get into the company to have you hire them. But having the handbook to reiterate what the company is about will help set the tone with what the employees work relationship will look like in the future. Okay. You should also have gender neutral language in there in today's society because of diversity and all those other cultural norms. We want to make sure that we're not saying or implying anything that is specific to a certain gender, because some people may be non-binary and we want to be respectful of that no matter how they identify themselves. So we want to make sure that having a neutral language can make a huge difference in impacting how an employee feels about the culture of the company. In terms of compliance policies, these are required that we really don't want to modify since they aren't specific to your company. So these are policies such as your equal employment opportunity, discrimination, and harassment policies. These policies are federal, and some of these are state policies, such as the harassment policies. We do want to make sure that you are staying in compliance and that even if you change the language a little bit, even by making a grammatical change, for example, that could easily put your policy out of compliance in some situations. So you do really need to be careful when drafting these policies when you come across that and working with an HR professional or using a certain software that helps you build a handbook. Drug-free workplace policies would include drug testing and substance abuse. This language regarding the use of medicinal marijuana or prescription medicine, it's good to have a policy that states employees cannot be impaired at work, even if they are legally allowed to use these drugs outside of work. You also want to have policies around compensation, including wage and hour information, state laws regarding overtime. Every state is different, believe it or not, but most states do follow the federal guidelines of getting overtime at 40 or more hours per work week. But you also want to include that as an employer, you are required to deduct certain withholdings as allowed by law, such as state disability insurance. In Massachusetts, most employers who do not have a private disability plan will have to ensure that they are getting the state paid family medical leave deductions out of their employees' paychecks. It's a very small amount. Employees probably don't even notice the difference in their pay stubs, but these are lawful deductions that should be coming out. Employees should be notified and you have to get their consent every year to make sure that these are deductions that they are going to be getting out of their paycheck. There's also policies regarding employee safety, and we'll talk a little bit more about that in a later slide when we talk about some policies that may be more applicable in your environment. You may be able to keep this general, but you want your employees to report any safety issues or concerns to you immediately and make sure that they know who to reach out and if someone gets hurt, right? So some employees make the mistake of hanging on to information until it's too late to report it. And at that point, medical attention may be too late, or you as the employer may be too late in filing a claim, depending on what your insurance, your workers' comp insurance policies are, okay? But the most important thing is to keep the injured's well-being in mind, right? So report any injury that you have sustained or that you have witnessed in person so that someone in the company will be able to take action immediately to get things straightened out. Now let's talk about some workplace policies to include that are going to be specific to your company. It's very important to have attendance requirements. A lot of hospitality industries are struggling these days in terms of attendance, whether employees are coming in late, having unplanned absences, or just no call, no shows. Okay, so it's important that you communicate what the requirements are for any planned or unplanned absences and what's considered a threshold for no call, no shows. The standard for most companies is a 3-day rule, meaning if an employee does not show up or call the company for 3 consecutively scheduled workdays, then they are considered to have abandoned their job. So they are resigning, okay? And that it's important to enforce if you do happen to come across these situations. It's tough for hospitality environment to have to face this because every body that walks through the door counts, right? To help run your business. But unfortunately, these things do happen, and we do want employers to feel comfortable enough to take a strong stand, right? A firm stand on this policy. Now, in terms of standards of conduct and performance, it's very important to include this. So some items such as no stealing or falsification of time cards for those employees that are a non-exempt hourly employee, it's very important that accurate timekeeping is tracked because under wage and hour laws, you do need to produce that if you are ever audited for any reason, okay, especially in Massachusetts. It's also important to have safety protocols and ensuring that employees are not violating things like the harassment, workplace violence, and drug and alcohol policy. Electronic technology is another hot topic that most employers are facing these days because of social media, safety, internet safety. And these are things that you should have something in the handbook. Even if your employees are not using a lot of technology in the workplace, it's still important to have some basics in there. So whether you want to specify that they should use the technology for purposes only and letting employees know that they shouldn't assume anything is private. Okay, many times employers will have employees send things, right, connected to the network. And there's really no guarantee of privacy because the employees are using the employer's internet connection, their property to conduct their personal business. So you also want to let them know that there should not be any expectation of privacy because of that. Other things such as passwords, right? Password protection is very important. Employees should not share passwords with anyone or even PIN numbers when they're entering in something to access certain networks or a certain machine. And then you also want to let employees know that you will not tolerate any harassment of employees, clients, or customers by way of electronic technology. And this also includes social media. This can be an issue if it creeps into the workplace. Even though it's happening outside of work on the employee's own time, you can take action if it's impacting the workplace. When it comes to benefit information like vacation, sick time, holiday policies, for anything with a summary plan document, you want to, again, keep these as brief as possible. For time off, vacation, sick time, those are going to be a little bit more detailed because you do need to have those clearly spelled out for employees to understand what the expectations are, when they're eligible for a certain amount of time, who they need to contact if they want to request time off. And in Massachusetts, there is the paid the paid sick leave law, in which employers must offer up to 40 hours of sick time to employees. If you have up to 10 employees only, then you don't have to pay employees for sick time. The employers with 11 or more employees, they do have to offer sick time. And we'll go over that in a moment as we go through the other slides throughout the presentation. In terms of handling confidential or sensitive information, it's important that employees understand that it's applicable to all employees in the company. And that's a good practice. But keep in mind, if you need a non-disclosure agreement for certain roles, that would be outside the handbook. Many times employers approach me and say, I want them to sign an NDA. And I want that included in the handbook. An NDA is a written contract. So anything that has to do with a contractual agreement should not be included in a handbook, and namely the non-disclosure agreement, okay? You can mention in the handbook that employees are expected to sign an NDA. There could be a policy on that, but the actual agreement itself cannot be in the handbook, all right? And then finally, we have the employee complaint process. as I've mentioned earlier, it's always a good idea to have a open door policy, and within each policy, let employees know who they can talk to if they have any questions or concerns. Ideally, employees should have a good relationship with their managers and should speak with them if there's an issue. But sometimes it doesn't work. They may feel that they need to go above the next level. So you also need to make sure that employees should feel comfortable going through the next step and contacting their manager's manager. And there should also be a third level, and that could be someone that's in upper management. Okay, so there's any concerns about employee complaints, please feel free to sit down with them and speak with them frankly. And sometimes employees may not feel comfortable speaking with you, so feel free to have them invite someone else to be part of these types of meetings too, just for support or even just a witness, so that employees would have some reassurance that there is some witnesses there and that there would not be any type of retaliation that could happen because of the fact that they're speaking up about something. All right, so now we're going to talk about the hot topics that most employers in Massachusetts should be looking into. It's important to keep in mind that employment policies are tied to where your employees perform the majority of the work. So if you do have a business located in New Hampshire, for example, and over the past year you hired one remote employee in California, you'll need to make sure that your handbook includes relevant policies for that one employee that's sitting outside in California. And also to find out which part of California that they're in, because as I mentioned earlier, California has a lot of state local laws and city laws that you do as an employer need to be mindful of if they fall under that jurisdiction. So these are the following hot topics that you should be mindful of, such as workplace harassment, Pregnant Workers Fairness Act notice, the Mass Paid Family and Medical Leave, the Mass Sick Leave, the Massachusetts Equal Pay Act or wage discrimination, and medicinal and recreational marijuana. So right now we're just going to start talking about the workplace harassment. When it comes to workplace harassment, best practice is to offer training at least once a year. And that's regardless of which state you're in. There are many states out there that have mandatory training for all employees once a year. One of them being New York, for example. But it's not mandatory in Massachusetts, okay? The one thing that is mandatory in Massachusetts is that the harassment policy itself, the actual verbiage, needs to be distributed to all employees, and that employees must acknowledge the receipt by way of electronic signature or have an actual signature from the handbook receipt page. So if you're creating a handbook this year, right now it's end of February, and you're able to distribute this handbook within the next couple of months, that includes your harassment policy in there for Massachusetts, the employee signs off on the handbook, which has the policy in there, then you're all set. You will have fulfilled your annual requirement under Massachusetts discrimination guidelines to have the policy distributed and acknowledged, okay? You do need to make sure that that is the case. If there's a year moving forward in the future where you go by without updating the handbook, you still have to find the latest verbiage, create a document, either have it distributed electronically and have the employee acknowledged electronically, or have them sign the actual acknowledgement form that you're going to attach to the actual document that you're physically handing out to the employee, okay? That's what the Massachusetts harassment policies are required, okay? Some employers have never distributed a harassment policy in their lifetime as owners of the company or managers of the company, and they manage to survive. It doesn't mean that they'll never get caught, right? At some point, it's going to catch up to them. If MCAT, for example, ever finds out that the employer never distributed that, and it only takes one phone call from a disgruntled employee to the state and say, yeah, I've been an employee for this company for many years and I have not once received a harassment policy distributed by my employer for us to review and sign. Okay, so it's important that you try to get this out. Again, the training's not mandatory. It's really the actual verbiage that needs to be distributed annually. Okay. Oops, went too far ahead. All right. Now, when it comes to Massachusetts paid family medical leave, there's two parts of it. You have the parental part, and then you have the medical part. Um, Most employees in Massachusetts would be eligible, but the eligibility would be based on their previous employment and other employers that are in Massachusetts and how much the employees have actually made in those past employments. Okay. And sometimes employees will assume that employers will know whether or not they're qualified. And the answer really is no. The only way to determine their eligibility is for the employees to apply directly to the state website through the Massachusetts Department of Medical Leave, and they have to make that determination for the employee. Okay. Um, Unlike nearly all other industrialized nations, the US does not have national standards on paid family or leave or sick leave. So for employers that have over 50 employees, they would be covered possibly by the federal uh, Family Medical Leave Act. But employers and employees need to meet certain criteria in order to be covered for that. So this Massachusetts state level paid family medical leave is a great option for those employers that have employees that need to take time off for any parental leave or medical reasons. So for the paid family medical leave, sorry, I should say the paid family leave, it provides parents and caregivers time off to address serious health conditions that include pregnancy and to care for family members with a serious health condition, to care or bond with a newborn or a newly adopted child, or a newly placed foster child, or for care of a family member who is a covered service member undergoing medical treatment or otherwise addressing the consequences of a serious health condition relating to the family member's military service. The PFML leave may be offered as a full-time leave or intermittent leave or a reduced scheduled basis, right? So it doesn't mean that once you apply, you have to take, all 12 to 18 weeks off, for example. It really all depends on the information that the employee provides to the state and the other documents from their providers, and to have the state determine what duration is the most appropriate for the employee in question. The employees may apply for this disability through the Massachusetts Department of Family Medical Leave website. The employees will be responsible for following up with the application process and keeping the employer informed of their leave application approval status. If they are approved for leave from the state, employers will need to ensure that they maintain communication with the employee during their leave of absence. So in essence, an employee gets the approval to take X number of weeks for full leave, all right? They're not reporting to work during that approved time. As the employer, you do need to follow that because the state has approved it, but you also have to make sure that you keep in communication with the employee to check in with the employee to see how they're doing, if their agreed upon return date is still on track, because sometimes medical leaves or parental leaves may have extenuating circumstances that could require extension. And if that's the case, it's up to the employee to apply for the extension with the state and have them work it out so that they could inform you as soon as possible if they need to extend their expected return date further out for another week, 2, or even a month, depending on what the situations are. So depending on the employee's eligibility, the Mass PFML may run concurrently with other qualified federal and state leaves. So in Massachusetts, I don't know if you're aware of this, but there's also a separate leave called the parental leave in Massachusetts only. And what that is that it's the precursor or predecessor, I should say, of this family medical leave law, all right? Before this law came into effect. the parental leave was strictly available to employees who need to take time off to give birth, to bond with a child, or to bond with a adoptive or foster child. Okay, that's purely what that leave was for. Okay, but with the Massachusetts paid family medical leave, that could run concurrently at the same time. The parental leave was only made for job protection purposes of up to 6 to 8 weeks unpaid, right? There's no pay required from the employer to offer to the employee for job protection, okay? But with this current paid family medical leave law, this could run concurrently with the parental leave. The employee will be getting possibly some benefits through the state during a part of the leave for job protection, and it could run at the same time with the parental leave. It gets a little bit confusing to track the two leaves. So if you ever have a situation where an employee does need to take time off to give birth or to adopt a child, please work with a professional to help you navigate through the timeline, because we do want to make sure you understand and feel comfortable talking to the employees about these types of leaves at the end of the day. Okay. All right. So let's talk about the Pregnant Workers Fairness Act. So what you want to do is make sure that employees that fall under this protection will not be discriminated against due to their pregnancy or conditions related to their pregnancy. What this means is that you as the employer will do your best to be flexible and provide employees the accommodations necessary to allow them to continue performing their work with or without accommodations. For example, accommodations could include providing frequent or longer breaks, adjusting work hours, modifying physical requirements to ensure employees can still accomplish their task with some changes due to their medical conditions. A private space for expressing breast milk should be provided to employees in the workplace. A space should be provided that includes a locked door, and the restroom is not considered an appropriate space for expressing milk. In terms of what adverse actions could happen, it's when it penalizes or punishes an employee for requesting or receiving an accommodation for pregnancy or related condition. So, for example, if you're denying an employee a promotion or other employment opportunity because she has a request for an accommodation that would be prohibited, that's considered an adverse action, all right? The employee will feel that they are being punished for being pregnant or having condition related to pregnancy that requires accommodation, and the employer is not giving them any fair advantage or fair treatment, I should say, because of that, all right? In addition, it's important to consider that an adverse action, an employer forces an employee to accept an accommodation she does not want, and that is unnecessary for the performance of the essential functions of the job. So there could be the opposite too. An employer may force an employee to accept an accommodation when she really clearly doesn't need it, right? And that could create a struggle. Employers may have the best intention to make sure that the employee is not overexerting herself during this time of her life, but at the same token, it's really up to the employee to voice their accommodation needs and to make sure they make the appropriate accommodation request as needed, so the employers can work with them. Employers cannot just push them to say, I'm cutting your hours because you're pregnant. If the employee can do her job the way she has done prior to pregnancy without losing hours, for example, she should continue to do that. All right. Now let's talk about Massachusetts sick leave laws. Now, this is a policy that is definitely mandatory, whether you have over 11 employees or not. Because as I mentioned, the unpaid requirement for Massachusetts employers is if they have less than 10 employees, versus employers that have over 11 employees, they will have to offer the paid sick leave. Okay. And the purpose of the sick leave law is to allow workers to take time to attend a doctor's appointment, pick up sick children from school, deal with issues related to sexual or domestic violence, accommodate public health emergencies, and businesses or school closures, all with job protected time they accrue. Employers are required to offer, again, either unpaid time off or paid time off. Some employers I've worked with that have less than 10 employees do offer to pay the employees sick time, and that's totally fine. Even though by law they don't have to, the fact that they are going above and beyond what the law requires them to does not put them out of compliance. All right. So this is totally up to you as an employer. If you happen to be in that space with less than 10 employees, the very least is that you do need to offer unpaid time off by law. But if you choose to want to pay them, that's totally fine too. You just need to make sure that you are offering it to all employees in your company, if that's the case. Okay. Now, there are two ways to offer the time off for accruing time, the sick time. Either they earn the time. So by law, employers must allow employees to earn 1 hour for every 30 hours worked, up to 40 hours in the benefit year. Or the employer can offer the time front loaded, meaning at the beginning of a defined 12-month benefit year, employees will receive up to 40 hours, depending on their employment status, right? So by law, the time off is based on a 40-hour work week. So if you're a full-time employee, then it's pretty much assumed that the employees will receive a 40-hour time off bank, okay? Whether they have to earn it or it's given to them at the very beginning of the year. So if you're front loading the time to the employees, that means the employees can use up to 40 hours, right? Throughout the next 12 months. And as long as it's for time that's considered eligible time off under the definitions of the sick leave law, all right? When it comes to a 12-month period, benefit time, that's up to the employer to establish. Some employers might want to do it based on the employee's anniversary date. Some employers may want to go by calendar year from January to December. And some employers may want to go create their own 12-month period because of, let's say, a fiscal year calendar they want to have that aligned with. Or in my instance, working with a lot of daycare providers, they want to go by the school year, all right? So they want to start on September 1st and ending, August 31st to align with their school year calendar. So that also works as well. The bottom line is that the state needs you to make that decision. They can't make that decision for you. So when you're creating these sick leave laws, determine what works best for you. And there are a lot of nuances when it comes to figuring out, how to offer the time, if there's going to be any conflict of time off requests, if you're doing it for a 12-month defined period for all employees versus having them do it by anniversary date. There's also more administrative work tracking each individual employees by anniversary date. These are things that you really do need to think about. And I would highly suggest that you work with an HR professional to help you navigate through this process. Personally speaking, working with clients throughout the years, the sick leave policy plus vacation policy are those policies that take multiple meetings to define how the final outcome should look like. All right. There's so many little pieces that go into making sure that there won't be any conflicting information if they do one thing versus another. So take your time defining these policies because these are policies that really attract the employees and retain them. And also with the Massachusetts sick leave law, it's by law required that you offer it. So you need to have a very good understanding and be comfortable administering this. Now, Massachusetts Equal Pay Act and wage discrimination. It's a very hot topic in today's world, talking about, what's considered fair pay and not feeling discriminated by law. There are 50 states that have equal pay laws. Let's see. Sorry, my notes are in scrambles right now. There are laws in many states in Massachusetts that have equal pay. Mississippi was the last state to pass an equal pay law in April of 2022. These equal pay laws include provisions on pay equity, pay history, and or pay transparency. So Massachusetts Equal Pay Act, also known as MEPA, says that employers cannot discriminate against employees because of their gender when deciding and paying wages. Historically speaking, female and male employees do have a huge gap when it comes to wages. Meaning employers typically pay a male employee more for the exact or similar type of job that a female would do. All right. And that's something that they're trying to eliminate. They're trying to bridge that gap so that there's more equity across the board. Employers cannot pay workers a salary or wage less than what they pay employees of a different gender for comparable work. The law defines comparable work as work that requires substantially the same soft skill, effort, or even hard skills and responsibility, and is performed under similar working conditions. Okay, so if you have two employees that work as a bank teller, they are not in the same location, but they are not too far apart. They work in similar environment, similar style. So they are expected to receive similar pay. One's male, one's female. All right. That's basically what this law covers. In terms of wage transparency laws, that prohibits employers from disallowing pay disclosures in the workplace and from retaliating against employees who discuss their pay with others. So meaning as an employer, you cannot stop or punish an employee from sharing his or her compensation or salary amount with others, even though it might kill you emotionally to know that your pay scales are being shared across the company. Unfortunately, under this law, you cannot stop employees from speaking to one another about this. Because it's simply not allowed, all right? So employees can share anything they want as freely as they want. In the past, I've had clients that approach me and say, I want to set up a policy that says that I won't allow that in the workplace. And unfortunately, that's not something that we could assist with because that would be breaking the law. All right. Right now, there are 17 states that go a step further, making salary history ban on applications to both public and private employers. Massachusetts has had this movement for over 10 years called Ban the Box. Hawaii was the first one that created that on job applications. So sure enough, employers would have no idea who what their applicants are currently making at their current jobs or past employment, because they want to ensure that employees don't feel that they have to disclose that information for privacy issues. Okay, so it's important for you to look at your handbook to ensure none of your policies violate these equal pay laws. For example, you may want to make sure that you have removed any policies that prevent employees from discussing their pay information. In terms of medicinal or recreational marijuana, I think I would be a millionaire by now for every client that's approached me to ask what they can do to prevent that from happening in the workplace. So as of today, 21 states and Washington, D.C. have enacted legislation to regulate recreational use of marijuana, while it remains legal for medicinal purposes in 37 states. That's a fun fact. So you'll want to make sure your drug and alcohol policy doesn't contradict medicinal or recreational marijuana laws in the states that you operate. Okay. A couple of things that on the slide that I want to point out. Marijuana remains an illegal drug under federal law. All right. So you may have situations employees are coming in under the influence of marijuana. In Massachusetts, it's considered recreational. And if they have a medical card that says that they are allowed to use it for medicinal purposes, you can't stop them from using it outside of the workplace. Okay. As an employer, you can still prohibit them from using it while at work for safety reasons. But if they show up for work and they are still a little intoxicated from their use from hours ago before reporting to work, you still cannot punish them for being high, I guess is the best way to put it. You can enforce discipline if they are acting incoherently and that you feel that they are jeopardizing others' safety in the workplace. A few years ago, I had a client in an urgent care facility that wanted to put language in there saying that employees may not take any medicinal or recreational marijuana. I think they said what, 12 hours before the start of their shift. And I ran that by a few of my other HR partners. I've gotten some feedback from some legal counsels that I worked with. And they said that by law, employers could not prohibit employees from using marijuana before they report to work because that's their own time, right? That's basically the bottom line. But if the employer does feel that the employee showing up to work is acting incoherently, they are saying gibberish, they are not walking steadily, for example, and especially if they're going to be handling equipment and they feel that they are not very stable at that point, then they can discipline the employee and have them go home. All right. But you cannot prohibit employees from doing what they can outside of work. And if they do it at work, then that's another story, obviously. If you have a no drug policy or no alcohol policy, then you can enforce that in the workplace, but not before they come into work. All right. I know there's probably a lot of questions out there about that right now. So I'd be happy to talk more about that at the end of the session. Now, something that is a topic that Katie brought up with me in our discussion a few months ago is pets and dogs in the workplace, in a restaurant environment. Okay, so today we see a lot of furry friends accompany employees and owners of the companies to work. And while they make great companions and often promote a happy, livelier environment, there are also a number of things to consider when inviting pets to work alongside us. So we need to make sure that we respect and recognize that some employees may have allergies to pets. As owners, you want to create an inclusive environment. So please consider checking that all employees affected by allergies or any respiratory concerns feel all right having dogs around. The company may need to designate pet-free areas or accommodations to ensure that the comfort of all of those that will be affected will be addressed. And then there could be some individuals that just don't feel at ease around animals for various reasons. Employees that have concerns or fears related to having pets in the workplace need to communicate them with management as soon as possible. They should not hold back and feel that they cannot speak up. This is a good example of an open door policy, right? If you have an open door policy, employees will feel more comfortable approaching you with questions like this. As the employer, you are committed to maintaining a productive work environment. So in order to promote this, you need to establish guidelines and best practices for pet owners to address potential disruptions. Owners need to ensure pets are well behaved and to help minimize disruptions. Sanitation is key. It's important to ensure that you will not find yourselves being out of compliance with the industry regulations and OSHA. The well-being of your guests, both human and your four-legged friends, is a top priority. If you're in the food prep realm of your job, you do need to make sure that you have food prep and cleaning protocols that will be fully enforced to ensure no contamination of your food products. Pets are required to be well groomed and free from any fleas or other parasites to prevent the spread of that to others in the workplace. All pets to be licensed as required by state or local law with current IDs. It's very important. Pet designated areas will need to be set up to dine with their furry companions, as well as equipping accessible waste disposal stations for pet waste. All in all, it is ultimately you as the employer's decision and responsibility to ensure all employees feel safe and comfort. Encourage employees to share their thoughts and provide feedback if they have questions surrounding pets in the workplace. Again, they're great. I love dogs. I love pets, but I do recognize that sometimes it may not be the most appropriate environment to bring some dogs into a workplace. So those are some things that you really definitely need to think about, and to make sure that you are covering yourselves when putting together a policy to welcome dogs in the workplace. Now, in terms of alcohol consumption, the $1 million question for you business owners is, would you allow it in the workplace? Restaurants, in a way, have alcohol embedded in their DNA. It's a practice that is cultivated from tasting product as a server or as a bartender to build their knowledge of the drinks that they're offering. And they are selling to something called a shift drink, which is the free drink one gets at their shift at the end of it. In some bars and restaurants, it's even listed on the menu to buy the kitchen a round of beers in some instances. Some things you should consider include creating a conduct and policy if alcohol is allowed, such as limiting the number of drinks to avoid being under the influence. And in terms of safety, if an employee is mishandling food and ends up not only hurting himself, but also imposing harm on others, who will be responsible for the hospital bills and potential lawsuits? I mean, these are accidents waiting to possibly happen, so you do need to be prepared to address that. You'll want to set clear expectations around this that you're willing and able to enforce. You will need to make sure that managers and supervisors are on board as well. This can be a tricky subject for your industry, so it's hard to avoid, right? Because you are in the hospitality restaurant business, and that's part of the culture. So you want employees to feel happy and that they're enjoying their jobs while serving drinks, especially, in a bartending position. But you also need to make sure that they are being responsible for themselves and for your patrons as well. So we're coming to the end of our presentation. As I mentioned in the beginning, there are some top 10 handbook mistakes that I like to go over with you before we end our presentation. The first one is that policies are not matching practice. As I mentioned before, consistency and fairness is key. So policies not matching the practice, it's important that employers recognize that if they decide to deviate from their standard practices and make an exception for someone, for example. Policies are pretty useless when they only exist on paper and aren't reflected in the way that you do business and manage employees. So this could actually harm you at the end of the day. If you are trying to hold an employee accountable to a particular policy, but it turns out that you aren't practicing many of those in the handbook, it's going to be pretty hard to justify why you are holding certain person accountable versus someone not accountable. Okay, so again, sometimes exceptions do need to be made. I've talked to many employers that have certain situations that do call for extenuating circumstances that need to be addressed, and that employers do need to be flexible. But at the end of the day, you want to strive to be as consistent as possible across the board to limit these liabilities. The second piece is failing to train your managers and supervisors. If your managers and supervisors haven't received training on your policies, it's going to be really hard for them to put your policies into practice and manage the policies. So you need the manager and supervisors buy-in in order for them to be able to help deliver and manage these policies and procedures in the workplace. Restrictive social media policy. So while it's a good idea to have a set of guidelines surrounding employee social media use, employers do need to be careful that they aren't infringing upon employees' rights. So even employers without any union employees need to abide by the National Labor Relations rules when it comes to allowing employees to exercise their right to speak about working conditions. Not revising the handbook regularly. So a handbook is a living document because, as we all know, things change pretty quickly, from new sick leave and family leave laws to your own internal policies. So the best practice is to review your handbook at least once a year to ensure it's up to date. You can make these less cumbersome for yourself and your employees by using electronic distribution and acknowledgement forms. We do encourage all of our clients to make their handbook available through the employee self-service portal in iSolve so that they can be easily redistributed when changes are made. Failing to include required policies. While policies are not necessarily required in a handbook, there are certain notices that must be given to employees upon hire. So for example, in Massachusetts, all hires need to receive the Pregnant Workers Fairness Act notice and a notice about earned sick time. There's no exception. Whether you're male or female, whether you identify as a male or female, these have to be provided to employees. We, as HR practitioners, strongly recommend you include these notices as handbook policies rather than having to remember to distribute them as a standalone notices to your employees. For me, I'm more conservative. I would advise my clients to just hand them out upon hire because, again, some of these notices in the handbook might be out of date by the time you hand them out to new employees, depending on how soon or how recent the handbook was updated. So it's best to obtain the most recent versions online, and you can download these on the state websites and hand these to the employees, okay? So that you know you've done your due diligence as the employer. The one-size-fits-all approach. So some businesses may need different handbooks for different populations of employees. So for example, I have clients that are in a law business, all right? So they may have a different set of handbooks for their office administrators versus their attorneys, because attorneys may have different set of rules and practices that they need to have in place due to their extreme work environment versus the administrative staff. So you may need to be careful about creating handbooks that are most applicable to both sides, to different sides of employees. I have employers that have seasonal employees that may have different handbooks because they have different policies and procedures as temporary employees. So there are many ways to build your handbooks. And the way that we work with our clients is that we learn about their work environment, about their employee population, and help them determine how best to create these handbooks. Either one handbook that would be appropriate for all their employee populations, or if need be, suggest offering different handbooks to different departments. And for my clients that have multiple states, oftentimes we do decide to separate the handbooks by state just to reduce any confusion. Overly detailed discipline procedures. Okay, so this is a tricky one in the sense because we want to make sure that employees understand what procedures are when it comes to disciplinary actions, but we also don't want to set the precedent that it's a procedure that we're going to follow to the T, right? So we need to let employees understand that the type of disciplinary procedure that employers will apply will depend on the severity or the type of infraction it is. So it's kind of a case by case basis, but applied consistently for the same cases. So for example, you have an employee that has, let's say, attendance issues versus an employee that's bringing a weapon into the workplace. If you have a policy that says all employees will receive a written warning, a second written warning, suspension, and then termination will be the last step, that means that for those two employees that I just mentioned, you're going to have to treat them the exact same way. And this is something that we want to ensure, to make sure employers understand that that is not the case, because that would create, in a sense, some safety concerns if you're just going to discipline the employee bringing in a weapon the same way as someone that's coming in late all the time. So the language that we encourage our clients to use when it comes to disciplinary action is that you would need to apply similar disciplinary actions for similar infractions, and that the type of disciplinary action applied will be dependent on the type of infraction it is. Okay, that's basically the gist of what you want to convey. Because if you say that you're enforcing every employee to go through the same procedure, then that could be more of a detriment to you as an employer and to the employees personally. Okay. Omitting at-will statements and disclaimers. So sometimes decision makers don't understand the importance of these sections of the handbook and want to omit them in an attempt to make the handbook shorter or to remove any legal language. But as I mentioned earlier, you want to make it clear that your handbook isn't a contract and that employment is at will, and make it clear to employees exactly what that means. So again, employment at will doesn't mean that you can terminate an employee for any reason at any time. You still have to have a, a reasonable decision, to make a reasonable decision based on facts, right? Did an employee violate company policy? Did an employee not meet job expectations? If so, have you gone through, the proper steps to retrain them on certain areas that they're not doing well? Or have you reviewed the company policies for certain things that the employee is not following in terms of their behavior? So those are things that you do need to have and to keep a good paper trail for, to show that you've done what you can to help the employee correct the behavior or performance and help them to get back on track and be successful. Using a boilerplate handbook. Now, this is the most common error that I've seen with working with brand new clients assigned to me in the past. They will send me a handbook that has very basic information. There's no state-specific policies and procedures. Sometimes there's not even the same correct state information in there. And then sometimes the employee counts off, so that there are certain policies in there that may or may not be applicable because the employer does not have those employee numbers in their workforce. So we need to make sure that it's great to have it as a template to help you understand what type of policies you should expect, but you do want to make sure that you are customizing your handbook policies to reflect your company's policies and practices. And that also includes making sure that you have the appropriate number of employees that you're taking into account in your workforce, and that's based on your payroll numbers of employee, and also the states that you're running your business out of. And the last part, failing to distribute the handbook. I've worked with clients in the past where we've spent months and months laboring over this beautiful document that we put together, only to find out a year later that they never put it into practice. They never distributed it, and it was it later on created some employment issues because the employees claimed that they were never conveyed that information. So it's very important that you do distribute the handbook as soon as it is ready to be released. And that concludes our presentation. I know we've gone over a few minutes today, so I apologize. Are there any questions, Katie, that have come through?
Yes, we had a couple come through, and thanks everyone for hanging on the line. Obviously, this is a big topic, multiple, avenues that you can go down. And I thought Sharon did an excellent job kind of trying to summarize it all in an hour is a big task. So thanks everybody for hanging with us. And I'll make sure those that had to drop off, the Q&A portion will be a part of that as well. So the questions that have come through have been, starting from the top. Is it okay to use the word seasonal for employees? We learned early on that the state uses the term seasonal very sparingly and only designates businesses like camps and landscapers as seasonal. I'll let you
That's a good question. So you totally can use the word seasonal, and especially if it's truly for seasonal purposes, especially if you're in a business where you only need a certain number of employees added to your payroll to address the needs of a busy work season. Hence, using the word seasonal is totally fine. I don't see an issue using it only for the industries such as camps or landscapers, as long as the company feels that it fits their environment, they can use the word seasonal, and that's totally fine. It honestly doesn't, to me, it's probably more short term than the word temporary, because temporary could be anywhere from a few weeks to maybe even up to a year, especially if it's a position that's meant to cover someone that's on a job protected leave. So in theory, I think seasonal would be more appropriate for those jobs that are intended for a very, very particular season in the workforce.
And then along the same vein, any insight into what constitutes full-time for a hospitality employee since their hours can be inconsistent? Is there something that you suggest as a way to phrase this for the handbook?
I would maybe use the word full-time equivalent if that's the case. So if it varies from anywhere from 35 to 50 an hour, what would you consider as a full-time equivalent employee? Most employers will say it's still anywhere from 35 to 40 hours, because most um, benefits, depending on who, if you're offering insurance, especially depending on who your carrier is, they may have specific language on what's considered full-time versus part-time. And under the ACA, it's anywhere over 35 hours to offer benefits according to the law. So 35 to 40 is pretty standard. If you have employees that have varying schedules or hours per week that could go up to 50 or even 60 hours, then you can say full-time equivalent.
The next one is a hypothetical scenario for
Mhm.
you. Let's say you hire two employees for the same role, but one employee negotiates a higher starting wage and the other doesn't. If one of those employees happens to be a part of a discrimination class, is that considered wage discrimination?
It could be. So if you're going to be offering one person who will negotiate a higher rate and the other person happens to be a minority and did not negotiate a higher rate, and then later on, somehow they speak or news gets out that they're not receiving similar pay, that could be considered a discrimination, and that's that's going to be on you as the employer for acting in that sense. So it's important that if you're going to offer similar jobs to people with similar skills, similar hours, then it's important that you try to align it so that they are closer. There's no huge gap in terms of what the wage is. Um, and sometimes it's hard, right? Because there may be an employee that you really, really desperately want to join the team and you'll do anything you want. I mean, you could to attract them, but at the same token, um, you really don't want to pay that much to other employees because it's a similar job. But because of this wage transparency and pay equity, you do have to at this point. So you do, in addition to those new hires that you're trying to pull in, we are now advising our clients to also look at their entire employee population, all the positions that they have, and do an audit to see what the pays are for all employees across the board, and try to find a way to find a middle ground so that they are being paid fairly and consistently. I believe what the law basically says that you can't decrease the pay amount for the highest paying employee for a similar position to come to an average. You actually have to bring up the lower paid wages to the highest paid wages amount just to be equal. Because if you think about it, it won't be fair to cut someone's wages just so that you can pay everyone fairly. So the law does say that it's important that employers do recognize that and try to pull up those wages to meet closer to what the highest paid person is for that similar position is.
It's helpful. The next one is about the marijuana policy.
Yeah,
If someone's job is operating machinery, forklifts, brewing equipment, etc., they come in high, but they're acting coherently, wouldn't that be a huge liability risk on the company's part to allow them to work to avoid disciplinary action? Would the company have to offer a payday? Mind is blown.
it is. It is. I've actually had, quite a few conversations with other clients that have come up with similar questions. And the answer is, again, based on the law. If they come in, they have taken marijuana or any other substance that is on their own time, you cannot do anything about it, meaning you can't control when or what the limit is to take that before coming into work. They can do whatever they want when they're off the clock. Again, most importantly is that they come in and they are not acting incoherently or putting others at risk. As an employer, the most important thing is for you to be very vigilant. I know it's hard. Sometimes you can't really keep an eye on every single employee that comes through the door, but you do need to take notice if you notice the employee is not acting like himself. He's walking unsteadily. His speech is slurred. And that you do need to pay special attention. You could approach the employee and ask, did you take something before coming into work? At least you know if there's something in their system, right? I mean, it's not to say that you're going to send them to get drug tested because of that, but at least you know, right? So that you can make the decision as to whether or not you feel it's safe for the employee to continue work, especially if they're going to be handling heavy equipment or tools that could possibly cause injury upon themselves or upon others. So you do need to be mindful of how that's going to be managed. And if you feel that it's better to take them off the floor, explain that to them why you feel that it's a safety hazard, and to offer them a chance to go home and rest for the day with pay, just for that one time, right? And if they make a regular practice of this, then that could be more of a conversation that needs to go into a deeper dive, because that person can have a medical condition that you do need to possibly accommodate, but we won't know until you get deeper into the conversation.
Well, that was all
Sorry,
the.
can I just follow up real quick on that question?
Yes.
And feel free to ignore me, but if we're out of time. But if said employee like repeatedly comes in high and but they're like, or I guess, okay, actually the question is, can I ask someone to disclose if they're medically using marijuana previous to starting? Like, can that be part of an interview process? Because if they're
No.
literally handling manufacturing equipment, but they're like smoking pot, then I cannot have them on a forklift, like regardless of they're acting coherently or not. That's
Right.
just literally not safe. Like if somebody gets hurt and somebody falls off the forklift, someone gets run over by a forklift, and then I find out this employee is medically carded, but they were high, what does that do for everyone involved?
So asking them if they're on any type of medication, that's actually not legal to ask,
Right.
right? Because
That's
that
why I
would
was like,
be
that feels
termination.
illegal. So how do I
Yeah.
make sure they're not high?
Right. So I think the best way to approach this for your interview is during the interview process, ask them, first of all, ideally you should have the job description, right? Outlining all the responsibilities, all the tools and equipments that the job is required to use, and ask them if they have any concerns about performing a job with or without accommodations. Now, normally when this question is asked, that's when employees or candidates should really openly say, yeah, I am a medicinal marijuana user. I have a license to use it. I have a card. And that I will be, using that for my health during my off hours at work. And that's something that they would have to disclose to you if you're able to ask that question in the right way. You don't want to ask them out open, are you taking anything recreationally or for medicinal purposes? So it's really just the best question to ask is if they can perform their work with or without any accommodations.
Okay.
And that's really the best way you can go about that. It's up to them to disclose that at that time, but later on, if you later on find out that they are taking it for, let's say, medicinal purposes, then you will have to have a conversation and say, all right, we're going to have to figure out how this is going to affect your job. Can we put you in a different position? Can we modify the job so that we're trying to ensure that you're not taking this medicinal marijuana on a busy day, for example, where you're going to be expected to use the machinery pretty much your whole shift, for example. So those are conversations you will have to have openly with the employee. And if there is an accommodation required, then the next step would be to have the interactive process started, meaning the employee will have to bring a form supplied by you to have their physician complete, to have it on record that they have this, a medical condition that requires them certain accommodations that includes taking medicinal marijuana. And then you'll have to evaluate at that time whether or not the job is still right for them.
Got it. Thank you.
You're welcome. It's not, it's not like a one size fits all, right? That's going to be what a ideal situation would be if that were the case, but there could be something of other, other extenuating circumstances that could make things a little bit more complicated. So if that's the case, then you really should be talking to legal counsel, just to make sure that you're not doing anything that could be construed as discriminatory or non-compliant.
Thank you.
You're welcome.
That's great. All right. Well, I think we are officially out of time. But I'm so grateful to everyone for being on the line. I hope that you found it informative. I will make this recording available this afternoon, and I'll include it in our newsletter as well. But thank you all, and particularly thank you, Sharon and the MP family, for going above and beyond for us always and providing this great resource for us. So thank you so much.
It's our pleasure, and hopefully you guys will all have learned something and be able to take away something from today's session. But feel free to listen to the recording again, and if you have any questions, please reach out to Katie, and then she'll be in touch with me to help answer any questions that you may have after revisiting the recording.
Excellent. Thanks all. Have a wonderful
Take care. Have a good afternoon.